Welcome back to Ben's Bench. Today I'm doing the first in a two-part series on landlord tenant law with a focus on the residential lease, not the commercial lease, because the commercial lease is more likely to have lawyers on both sides of the negotiations, whereas the residential lease is more of a tenant finding an apartment and then the landlord presenting a contract that the tenant either signs or does not. And there's not really much negotiation. So I'm going to focus on that particular type of landlord tenant law today and in the next video. The origins of landlord tenant law go all the way back to feudal England, when landlords were, as the name suggests, owners of parcels of land, and tenants were the farmers that worked that land. Now, because the nature of the leasehold estate was agricultural in nature, if the tenant did live in some sort of dwelling on that land, it was the tenant's responsibility to maintain the housing. That, of course, is very different from today's system, where people rent residences, places to live, not parcels of land to farm and places where they may or may not build a house. People are signing residential leases to live there. So the law has adapted to the current times and circumstances that we live in now to be more tenant-friendly than it was in the past. Even though landlord-tenant law is often a subject covered in a property class in law school, it's really now more of an area of contract law. The residential lease, the commercial lease as well, but I'm focusing on the residential lease, is a contract. And a contract is simply a series of promises between two parties. The tenant makes a promise to pay the rent every month or week or whenever it's due, and the landlord promises to give the tenant a place to live. And that brings us to the topic of today's video, which is the implied warranty of habitability. It's one of the promises in the landlord's part of the contract. It exists in every state. It exists in every written or oral residential lease, and it cannot be waived. Now, landlord-tenant law varies from state to state, so there's no universal definition of the vital facilities or fit for habitation, but generally speaking, there are some things that are going to be pretty basic, such as compliance with housing codes. If a house is not up to code, it probably isn't habitable. There are also going to be things like functional and safe plumbing and electrical systems, adequate heat in the wintertime, and protection from the elements, that is, adequate sealing around doors and windows, roofs that don't leak, walls that aren't cracked or broken, etc. It also imposes on the landlord the duty to make sure that the apartment is free from vermin, such as insects and rodents, and other health hazards, such as mold. So when is the warranty breached? Well, the first step is that one of the state-defined grounds must occur, and it must not be the tenant's fault. The same is true of the landlord. If the landlord acts or fails to act, and as a result something is damaged, of course the landlord has to pay for their own damages. That is just fair. But what if the damage is no one's fault? What if it's simply due to deterioration and wearing out from use over time? Well, that is also the landlord's responsibility. One of the things about being a landlord is that sometimes repairs need to be made, and it is the landlord's responsibility to make those routine repairs caused by the use of the property as a residential home. So for a breach of the implied warrant of habitability, whatever problem is arising must not be the tenant's fault. If it is due to the landlord, or simply due to deterioration, then it will constitute part of the breach of the warranty. The second step in the breach of the implied warranty of habitability is that the landlord must be notified of the problem and fail to fix it within a reasonable amount of time. This is important because it does put some responsibility on the tenant. The tenant has to at least tell the landlord what is wrong and give them a chance to fix it. Of course, the landlord doesn't go looking for these problems. They have to be notified. So only if the tenant notifies the landlord so that the landlord knows about the problem, and the landlord fails to fix the problem in a reasonable amount of time, will there be a breach of this warranty. An illustration of a breach of the implied warranty of habitability can be found in a very old case from the state of New Jersey, where a woman rented a home and the toilet had a crack in it. Water was leaking everywhere. She had to clean it up multiple times a day. She notified the landlord, and he didn't fix it for so long that the court found that there was a breach of the warranty. So, the first step, a vital facility breaking down. A toilet is obviously necessary in a residential lease. Landlord is notified. Landlord fails to fix the problem. You have a breach of the implied warranty of habitability. Now, when the landlord breaches the warranty, what can the tenant do? Now, because the law varies from state to state, the options available, as well as the procedures for how the tenant might exercise those options, are going to vary. Generally speaking, however, there are 4 options. Some states have adopted all of them. Some states have adopted some of them. All states have adopted at least one of them. The first remedy is the oldest and possibly the most obvious. Move out. This looks at it as simply a breach of contract, where one side has failed to hold up their end of the bargain, so the other side is free to terminate the agreement. In this case, the landlord has failed to provide habitable housing. Tenant's free to leave. The problem with that remedy is that it might not be feasible. Moving out is expensive, time-consuming, and sometimes it's impossible. There might be a dearth of affordable housing, and it just might not be an option for some tenants. So what happens then? Fortunately, there are, in some places, 3 further remedies available to the tenant. The first is what the woman did in the toilet case that I mentioned earlier, which is to repair and deduct. This involves the tenant fixing the problem themselves and then deducting whatever that amount is from the next rent payment, and of course submitting a copy of the receipt along with the payment. Basically saying, you didn't make this repair, so I had to. Here's the rest of the rent that you're owed. And then that way the tenant has paid the entire rent that is due in total, and the landlord has taken in only the amount of money that he would have made if he had gotten the repairs done himself. Essentially, the tenant is paying for the repair and then passing the cost along to the landlord. The second option is something called a rent abatement. This is where the tenant pays the full monthly rent, but then sues the landlord for a refund of the difference between the actual rent paid and the value of the premises in the state that it was in, given whatever problem existed at the time. The third remedy is to withhold rent. This is where the tenant says to the landlord, essentially, you didn't do what you were supposed to do. Now I'm not going to either. This remedy works a little bit differently from a procedural point of view. The track that it takes is that the tenant refuses the rent, the landlord demands the rent, the tenant refuses again, the landlord then sues for an eviction, and then it is in the eviction proceedings that the tenant raises the defense of the implied warranty of habitability having been breached, basically saying, I don't have to pay rent because I was living in a place that wasn't habitable. Most of the time, in those circumstances, the judge will say, all right, it's true that that is a defense, but you don't get to live there for free. So based on the problem or problems, this is the amount of money that you should have paid for rent. The judge will then order the tenant to pay that to the landlord and usually give them a certain amount of time. And then if they fail, then they will be evicted. It is important to remember that I am only explaining general information here. Different states and sometimes even local governments might have different substantive rights and different procedural rules for how tenants go about raising these defenses. So if you are facing some sort of landlord-tenant issue, you absolutely should speak to a local attorney who is familiar with the law and the regulations and the ordinances and the procedural rules in your area, who will be able to help you with your specific situation. For example, some states or municipalities might require a report to a housing authority or a housing board, possibly even an inspection, before the tenant exercises any of these options. Some states might require that instead of withholding rent, the tenant deposits the rent into an escrow account until whatever court procedures are resolved. These are things that you need to know going into it, and a lawyer will be able to tell you not just what rights you have, but how you can go about exercising them. Well, that's all for today's episode. Join me next time for a discussion on self-help evictions. But until then, we're adjourned.